Hello, UpLevel community. I'm so excited to jump in here because from time to time, as you guys know, I'm always interested in helping you take your financial literacy to the next level. One of the things that is impactful to business owners are their relationships with employees. And many of you may be aware that earlier this year, the Federal Trade Commission, the FTC, issued a brand new rule that essentially did away with this concept of a non-compete. It was all the rage, if you will, passing around media earlier in 2024. But there's been a lot of contest to that specific rule because, as many business owners know, the concept of a non-compete is very, very important and critical to their respective businesses. So as you can imagine, a number of different businesses have filed lawsuits against the Federal Trade Commission, specifically with regard to this rule stating that non-competes are now illegal and unenforceable. And a component of that rule was that every single business that has a particular non-compete in place on September 4th, 2024 is required to send a notification to those individuals that have non-competes that the non-competes is no longer in force, right? So it's been void through this rule with the FTC. However, as you can imagine, again, a number of businesses have filed lawsuits against the FTC. Notably, there are three very, very large cases that were outstanding. One in Texas, one in Florida, and one in Pennsylvania. And earlier this summer, all three of those cases got an initial ruling from the judge. Within Texas, that particular case was Ryan LLC versus FTC. And in that particular case, the judge sided with the business, specifically saying that for that specific business, the non-compete was going to be unenforceable. And the judge reserved the judge's right to come back and revisit the decision as to whether or not this should be unenforceable for all businesses. Then in Pennsylvania case was ATS Tree Services versus FTC. In that particular case, the judge ruled that for that particular business, it was unenforceable, but for every other business, it was enforceable, meaning the FTC could enforce a ban on non-competes. And in Florida, the Villages, and for many people who live in Florida understand what the Villages is, the Villages versus FTC, in that case, again, the judge held that it was pretty much on hold, if you will, for the Villages, and the judge is going to revisit whether or not it should be applicable to any business outside of the Villages environment. The whole reason I wanted to jump in here with you today is to let you know that the Texas judge, in the Texas case, Ryan LLC versus the FTC, has now made a final determination on this particular case and has ruled that the rule, meaning banning non-competes for business owners, is now unenforceable, meaning it's out the window. Whatever the FTC's hopes were with regard to this rule, it is now no longer enforceable for any business, meaning the FTC cannot enforce the business to void out their non-competes. Now, why is this critically important? The case in Pennsylvania has said, well, no, it's only unenforceable with regard to the plaintiff in that case, and for every other business, it is enforceable. So those two circuits differ, and that is sometimes referred to as a circuit split, which will require the FTC to appeal this to the appeals courts, if you will, and then the next stage would be going to the Supreme Court. So why am I sharing this with you? Because if you were a business owner that does have an existing non-compete, you may have been informed that on September 4th, you have to put out this notice to all of the employees that have a non-compete. Well, that is now not the case. It is unenforceable for every business because of the ruling that the Texas court made. Even though there's a different ruling in Pennsylvania, the Texas court saying that it is unenforceable across the board is going to be the thing that is the driving factor here. So if you were thinking about having to send this notification out to your employees, you don't have to do it, at least for now, until the FTC appeals. Now, here's my position. I actually don't believe the FTC is going to appeal. And there's a few reasons for it. One, we're in an election year, and this is probably not the dynamic that the current administration's FTC really wants to go down, especially given so close to the actual election itself. And regardless of the outcome, there are bigger fish to fry here. So it is likely that even if the FTC does appeal and it makes its way to the current Supreme Court, it is highly probable that the current Supreme Court would rule that this is truly an unenforceable overreach on the part of the FTC. And a lot of that goes to something called Chevron deference. You may have heard of the Chevron case where agencies of the executive branch were essentially able to interpret law and essentially create law through policy. And Chevron deference gave a lot of, in effect, deference to those respective agencies for understanding the nuances of what was happening, boots on the ground type of situations between those agencies and the respective individuals within the realm of regulation, right? So for instance, the FTC with regard to business and the FDA with regard to food and health, et cetera. But this Chevron deference being thrown out earlier this year by the United States Supreme Court likely would indicate that the current Supreme Court would side with the Texas judge, because the Texas judge has essentially said that the FTC has made a significant overreach beyond what Congress has permitted in actual law. And further, that this particular rule was capricious and arbitrary, which essentially means there's no real reason that the FTC should be engaging in this type of limitation on business owners without there being an actual law that Congress has drafted, has ratified on their own part, and then ultimately it was signed into law by executive signature. That being said, I wanted to keep you in the loop with regard to this development because it does impact a significant number of business owners out there. So if you were worried about having to throw out your non-competes, well, you can take that worry off the table for now. I wish you well in your journeys. If you have any questions, be sure to leave them in the comments. Till next time, bye for now.